you need to pay it. Too many times, I think people just go ahead and knee jerk and pay it, and they don't really have any responsibility to pay that debt. And it may take, 5 minutes to call your attorney and check and see whether or not you need to pay that debt. And in a world where there is an estate and you are doing a probate, there is a process whereby creditors are noticed. It's called the notice to creditors. And this is where that ad, you see that in the section of the paper with all that really small print, the notices section, and they have all those notice to creditors in there. If you have a debt against a particular estate, here's who to contact and how to process your claim, and you have to file a claim. And if a creditor files a claim with the court, then the personal representative of that estate is notified, and they're given 30 days to either let the claim stand or object. And if they object to the claim, then that shifts the burden back to the creditor to either go away or to file an independent action seeking that payment for that debt. So again, don't just knee jerk into paying the debts because you got a bill in your late spouse's name. Check with your counsel on that. 877-943-9673. 877-943-9673. I'm your host, Attorney Patrick Smith. This is the Attorney Patrick Smith Show, and we will be with you the remainder of the hour to answer all of your legal questions. I want to say a very special thank you to all the residents of Coquina Cove in Largo, Florida, who invited us out to speak at their board meeting this past week. Great turnout. We had a huge in-person crowd and then a bunch of people watching via Zoom as well, and it was a very erudite group and a very lofty Q&A session, definitely more lively than a lot of my other crowds. And I got lots of fantastic questions regarding trust and sort of where to situs them. There was one particular young lady who wanted to know about creating her trust in Florida, even though she was a resident of a different state. And the critical point there was you want to create the trust in the jurisdiction of your residency. And it's one of those situations where that sometimes comes up for debate. And hence, this is the reason why we did the show on Florida and New York. And this question comes up all the time. Clients are actually debating this. Will I situs everything? Do I want to be a resident of Florida or this other state? Well, the procedure for that is you have consultations with attorneys in both jurisdictions. And then you can weigh and balance those options before you make that decision. So you sort of look before you leap in that case. So again, thank you to everyone at Coquina Cove who came out. We have a couple of speaking engagements coming up. Both are actually on Tuesday, February 27th with Raymond James and Cindy Richards. We will be doing a presentation at the Villages Public Library at the Pinellas Plaza. That will be at 11 a.m. on February 27th. I will finish up from there and drive straight to the Canal Court Rec Center. And that will be at 1 p.m. And that is for they say up in the villages, there is a group for everyone. And it's presentations before groups like this that make me realize that, because we will be presenting for the pet parrots and their parents group. So that will be at 1 p.m. I imagine that will be a presentation largely on pet trust. And we can talk a little bit about pet trust now, actually. But if you need a speaker for your group or organization, the office line. And again, this is the office line you can call for your complimentary consultation on estate planning as well. Or you're welcome to email us directly, patrick@attorneypatricksmith.com. But again, the office line, if you want to schedule your free consultation or book us to come in and speak to your club or group, 877-754-6764. 877-754-6764. Again, that's the toll-free office line. Office lines are open Monday through Friday, 8 a.m. to 4:30 p.m. And you can call 877-754-6764. And we would be happy to book you for that consultation or come out and speak to your club or group. And we'll keep you posted as speaking engagement season is in full effect. We'll keep you aware of all of them if you want to come out. And if you've attended one and you want to call in with your feedback or email me your feedback, I love the feedback because we're always looking for ways to make the presentations better and more helpful for you, the listener. 877-943-9673. 877-943-9673. That's your live and local studio line. Open phone lines will get you queued up. And you can call in now with your legal question. 877-943-9673. And we kicked off the show by talking about widows and widowers and the sorts of issues that that are facing different widows and widowers out there regarding the anxieties of their passing and making the funeral arrangements, contacting Social Security, working with the attorney, and also we kicked it off really by talking about the number one thing needing to be done was focusing on your grief and not turning a blind eye to it, and making sure you reach out for help, either professionally or talk to a family friend or a pastor or someone that can be entrusted with listening to you go through the grieving process. And there is just something therapeutic about getting it out. So we encourage you to do that. And we then talked a little bit about our presentations from the past week and some upcoming presentations. And one of those is before a pet parrots and their parents group. So let's talk a little bit about Pet Trust. People love to be good stewards of their assets for their family. And a lot of families include furry family members. So people often carry it to that degree. And they say, I want to make sure, and I did several of these trusts this past week, where people say, well, if we have any animals, we're going to make sure to set aside X number of dollars for the care of any animals we have and make sure that they go to this person. So a lot of people don't know that you can do that. And oftentimes it'll come up in the consultation. They'll say, well, other than our furry friends. And I'll say, oh, you have animals. Would you like to provide for them? They say, we didn't know we could do that. Yeah, you certainly can provide for them. So if you want to provide for your animal, you'll just create within the trust, a pet provision that says to whom the animal is going to be devised and how much you would like to go with that animal. And that's sort of based on their life expectancy and also the type of animal. I would say in sort of the top 4 animal categories, if you want to call in and guess, you can call in and guess the top 4 animals and that are left money in estate plans based on my experience. So if you want to call in and guess, we'll play a little guessing game regarding that. 877-943-9673. 877-943-9673. Patrick@attorneypatricksmith.com to email your question. Patrick@attorneypatricksmith.com. So again, you can email us and we'll answer your question live on the show, or you can give us a call now, 877-943-9673. And yeah, sometimes you see cases where people want to leave the entire share to an animal or to a group of animals. You see people who leave substantial sums. But the point is, you can provide for care for your animals. And a lot of people like that idea, just knowing that when they enter eternity, if they do so before their animal passes away, their animal is going to be cared for. And that gives them peace of mind. So 877-943-9673 to be part of today's show. And again, that toll-free office line, for those of you wanting to book in Sun City Center, Clearwater, Claremont, the Villages, Sarasota, any of our office locations, that toll-free office line, 877-754-6764. 877-754-6764. All right, let's go to Joanne in Sarasota. Joanne in Sarasota, welcome to the Attorney Patrick Smith Show. How are you today, Joanne?
Okay, very good. Thank you. And yourself as well, I hope.
Everything's fine. Is it rainy down there in Sarasota today?
No, it's sort of grayish.
All right. So it says you want to guess one of the top 4 animals. Go.
Well, I think a Shih Tzu or a Peekapoo or one of those. Yeah.
That's correct. Dog is number 3 on the list, Joanne. So well done. Do you want to make another guess?
I wanted to ask you.
Yeah, go ahead.
Do you remember that you asked me what about the game and who I thought would win? I wondered if you thought about it when it happened. I said overtime with the Kansas City.
I was bragging about you this week, Joanne. When that happened, I went to the office on Monday and I said, Joanne from Sarasota called it exactly. And Joanne, if you would have put money on that in Vegas, that it was going to go in overtime and the Chiefs would have won it in overtime,
yes,
the bundle you would have won. I'm not promoting gambling, by the way. I'm just saying, had you placed a bet to that effect,
I thought about that.
The windfall you would have come in. I mean, the IRS would have sent you roses and a thank you note for winning that kind of money.
Well, when it happened, I thought, gee, I should have placed a bet.
It's not a bad idea. And I mean, if you could always know the outcome and then place the bet, but that's why they call it gambling and we don't promote it. So, but yeah, so absolutely, Joanne, if you know, hindsight for you was perfect and your foresight was perfect as well. So, Joanne, well done on predicting not only who would win the game, but that it would go into overtime. And that's only the second time in Super Bowl history that
That's
it's ever.
right.
So, I mean, impressive analysis, Joanne. Any other predictions for the future for us?
No, I'm off the football thing.
All right. What about presidential predictions? You got any predictions there?
Dare I say so? It'll be great confusion, but I think Trump will get it.
All right, there you go. You heard it first. Joanne's 1 for 1 on predictions, folks. So hey, you know, listen, there's her prediction. Any other guesses on the top 4 animal list that are left money through estate plans, Joanne?
I would say poodles, or I would say poodles.
Well, dogs is the category. So you already guessed dogs. Dogs are number 3 on the list.
Oh, what did you ask me? I'm sorry.
Yeah. So the types of animals, the top 4 types of animals that are left
Types of animals.
that are left money as inheritances, and
Oh,
dogs, cats are number 4. Cats
Yeah.
are number 4 on the list. All right, as long as you keep guessing one of them, I'm gonna let you keep guessing, Joanne. So you got number 4, which was cats. Number 3 was dogs. You want to go for number 2 or number 1?
Goodness, birds, parakeets.
Birds. That is impressive. Birds. A lot of people miss that one. So birds are actually number 1 on the list. Yeah.
I can believe it. I had parakeets all my life. They're
Well,
fun.
I love seeing someone who is in their 70s or 80s go out and buy a bird that has a 75-year life expectancy. I mean, that is the definition of optimism. You know,
That truly
that
is.
is just saying, look, things are going to turn out fine, and I'm going to go buy this bird that'll live 75 years and expect to be here the whole time. So
And talks to me.
yeah, yeah, and so so I'm excited to speak to this pet parrots group on the 27th, because I presume this will come up. And all right, you want to guess? You're 1 away from completing the top 4 list, Joanne. So any guess on what number 2 is?
Okay, let me think. Monkeys?
No, but good guess. So if I'll give you one more chance, Joanne. One last guess.
Boa constrictors.
No. That's wow. Way to go outside the box, though. No, definitely not. I've never had anyone leave money for snakes or any sort of reptilian creature. But that's a great point, Joanne. That probably will happen now that you called in with that thought. So,
Right.
Joanne,
Well,
you're
have a
always a
good
delight to
day.
talk to. You too. Be safe out there and keep those amazing predictions coming for us. Okay, Joanne.
All right. Bye
Bye
bye.
bye. 877-943-9673. That's your live and local number to be part of today's show. 877-943-9673. And you can call in now, live and local, open studio lines. You can guess number 2 on the list. So number 1, again, was birds. Number 2 was, we haven't gone over number 2 yet. Number 3 was dog. Number 4 was cats. So if you want to call in with your guess about what number 2 is, we'll let you take your guess or your legal question. 877-943-9673. 877-943-9673. Yes, we're still on SCOTUS watch for the decision regarding President Trump and the ballot. And I'm just hoping that it comes out early in the week and not on a Friday afternoon when we have to do immediate rewrite of all the show prep that we do. So stay tuned. We will keep you posted as that decision comes down, and then we will do a thorough constitutional law analysis. Yeah, we try to stay away from the politics side of it. There's other guys who do better shows for that kind of stuff. I like to bring you sort of the legal angle regarding that particular analysis. So we will keep you posted and then do our full analysis. I'll look up and see what show it was, but a few weeks back, we actually did the primer show for the actual opinion regarding Section 3 of the 14th Amendment as a disqualification clause. And so for those of you who are regular listeners, you're already prepped for the discussion and analysis of the opinion. But for those of you who are not, you can actually go to the website again and scroll back through the shows and find that show if you want to listen to the prequel, if you will, to the analysis of the forthcoming Supreme Court decision regarding President Trump and his ballot access. I believe it's in the state of Colorado. 877-943-9673 to be part of today's show. I'm your host, Attorney Patrick Smith. This is the Attorney Patrick Smith Show. All right, next we're going to Kevin in Apollo Beach. Kevin, welcome to the Attorney Patrick Smith Show. How are you today?
Very good, thank you.
Good. How can we help you?
I was just wondering about I understand the trust, but protecting the estate from creditors. My understanding is you pretty much in the state of Florida you have to go through probate to begin the clock, and I believe it's 2 years. Is that the best way? Is to set some assets up that you have to go through probate?
So nothing in the trust has to go through probate. The 2-year statutory bar is if you don't publish a notice to creditors. So if you publish a notice to creditors, that will shorten it down to that 90-day window. If you don't do that, then you're under the 2-year bar under the statute.
Oh, so you can just publish a notice to creditors. You don't have to go through probate, and in 90 days, creditors have.
Oh, I see your point. So how do we publish a notice to creditors if we're not opening a probate? So a lot of times what you'll see people do is they will allege some small amount of personal property and say it's $500 in personal property just to open a probate for the sake of publishing a notice to creditors. If the creditors aren't known, a lot of times people will just wait the 2-year statutory bar, or they feel comfortable and confident they know all the debts, so they won't publish an NTC at all. I think the attorney's job is basically just to lay all these options out for the clients so that they know what they're picking.
So again, you can but you have to go through probate to get that. You have to set up something, small asset amount, to go through and set that 90-day creditor limit.
Yeah, because to sign the NTC, unless the statute changed, I don't think it has, to sign the notice to creditors, you have to be the court-appointed personal representative.
Okay, that was my question. I thought that was just odd. I had a family member pass away in another state, and all you had to do is publish something in the local paper, and you're done. You didn't have to go through probate or anything.
Well, different states have different laws. It's a different jurisdiction. So, yeah, last in here, to sign the notice to creditors, because I know it's a timing issue. You can't sign that until you're appointed. But a lot of times you can open just these perfunctory probates without, so to be clear, Kevin, if you open one of these probates, that doesn't mean everything in the trust is now going through probate. You just opened a probate sort of as a strategy to expedite the expiration of a creditor's period. You're not probating everything in the trust.
I got that. Okay, that was my question. Thank you very much.
Thank you, Kevin. Have a great Saturday. All righty, this is the Attorney Patrick Smith Show, 877-943-9673. I'm your host, Attorney Patrick Smith. All right, let's go to Jesse in Cape Coral. Jesse, welcome to the Attorney Patrick Smith Show. You have a guess on our top 4 list, number 2. Go ahead, Jesse.
Yeah, Patrick, I would think it would be a horse.
You got it. You got it, Jesse.
Those are expensive.
You're not kidding. Stable fees. There's a reason they call horse racing the sport of kings, and you need that kind of wealth. I was talking with someone, this was a while ago, about polo. I don't play polo, but I said to someone, so if I was going to get into it, like, what would I need? And they said, well, you need, I said, I need a horse. They said, you wouldn't need one horse. You need at least 4, was what I was told, to get through a match. You would switch out horses throughout the match. This is what I've been told. I don't know. I don't play polo. And I said, okay, so I'm going to buy a horse. Now, I don't want to buy the Ferrari of horses, but I want to look respectable out there. Like I want, sort of I want the Nissan Altima of horses. Like, it's a respectable car. So at the end of the day, he said about $250 a horse, $250,000 times 4. So I said, okay, so to be clear, we're $1 million in on horses, and we haven't begun to do anything else. So yeah, Jesse, don't expect to see me playing polo anytime soon, but great job on guessing number 2, Jesse.
Well, thank you. Hey, I got a question for you.
Go ahead, Jesse.
All right. So my mother-in-law passed away a while back, and going through everything with her estate, is there a checklist on how things are done, or do the lawyers just do it like, nilly-willy, or?
Well, so
I mean, can they give you a real timeline on, it? Because I said, well, how long is this part going to take? And their answer was, well, I've got to do this, I've got to do this, I've got to do this, I got to do this. Well, that's fine, but how long does that take? Just if you can give me an idea.
So to be clear, Jesse, this was your mother-in-law's attorney?
Yeah.
Okay.
Yeah. Yeah.
So it wasn't
that's who we're going through probate with the estate.
but it wasn't your attorney, correct?
No.
Okay. So
No.
the short answer to your question is, in a typical probate, here are the steps. And we did a show dedicated just to the probate process. But in a nutshell, Jesse, it's petitioning the court to open the case, admit the will, appoint the personal representative. Within 60 days of those letters of administration, which those are the documents that empower the personal representative to go marshal assets, settle debts, within 60 days of that, there's a reporting requirement to the court called an inventory that's due, where they have to report the date of death value of the assets. And what I tell clients all the time with that is just make sure you meet the deadline. Even if you find assets later, we can always amend the inventory. What we don't want to do is miss the deadline and be delinquent on the inventory. The notice to creditors will run with that concurrently, typically, and that's a 90-day window. Then at the conclusion of that, there's what we call a statement regarding creditors, and we, file the satisfaction and releases showing we've paid all the valid creditor claims. And then there's a full and formal accounting after the taxes have been settled. And that's usually the big hang up right now, Jesse, is finalizing the taxes because the IRS is so backlogged. So that is the one thing.
We're sitting there with the check, but we don't know who to divide it up to yet.
Well, have they finalized the decedent's tax return yet?
I'm not real sure on that.
So that's why that's the step.
My wife is dealing with it.
Yeah, that's the step immediately precedent to the accounting. So once you finalize the taxes, that means all creditors have been satisfied, taxes have been finalized. Then
all that has been done.
Okay.
Yeah, all that has been done.
Then there should have been what we call a full and final accounting with a proposed intent of distribution, where you lay out, here's where we started, here's what we spent, here's how we derived your share, and here's what we plan to distribute to you at the end of a 30-day period unless someone objects.
So what's normally, how long does she passed away in July?
Yeah. I mean, that's, I would say that's within the realm of the reasonable, Jesse,
yeah,
to be honest with you. So, I mean, at the end of the day, each estate's like a snowflake. No two are exactly the same. And that's why it's hard to do a checklist. We've tried for years to do that, but it eventually turns into a phone book that's just so discouraging. So that's why I just do the old fashioned in-person consultations with clients, whether they're widows or widowers or they've lost a parent. We'll sit down with you free of charge and just walk you through everything that's sort of nuanced for that estate. It's better than any checklist, Jesse, I assure you. And that's, as long as I'm in practice, we'll offer that complimentary consultation for anyone who's lost a loved one so that they can get guidance, whether they hire us or not. They can get the guidance on just knowing which direction they need to head.
Right. Okay.
All right. Jesse, thanks for listening to the show.
Thank you. Have a great day.
You too, Jesse. Bye-bye. 877-943-9673. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Already an action-packed show. Talked about widows and widowers and alleviating their anxiety. Some of our speaking engagements, Pet Trust. We have our SCOTUS watch on the forthcoming President Trump opinion regarding his ballot access in Colorado. 877-943-9673. If you want to be part of the Attorney Patrick Smith Show, give us a call now. Next, we're going to Lakewood Ranch, and we're going to talk to Tom. Tom, welcome to the Attorney Patrick Smith Show.
Hey, good morning, Patrick.
Good morning, Tom. What's going on?
I just listened to your the little discussion about snowbirds, and apparently you had a New York and Florida program a couple of weeks back. I'm a snowbird. I don't live in New York, but my question is: we claim residency in Florida, but we own property and have a business in another state. And I've always wondered about, if it came down to, is it just our decision as to where we claim residency, or what are the qualifiers, and especially in an estate between the two states that we live in, and where the taxes would be paid should we were to pass?
Well, you're right. It can be a gray area. And I think with Florida, it comes down to the intent. And if there's any one thing you can do that's probably outcome determinative of the intent, it's called a declaration of domicile. And you can file it yourself with the county seat in the county of your residency. And basically the form reads something like this. Prior to this date, I was a resident of wherever, New York, Michigan, Pennsylvania, something like that. But this date forward, I am now a resident of the state of Florida, and you file that with the county. There's other things. You don't need to do the declaration of domicile. That's just one of the things a lot of people like to do because they feel like it's a formal codification of their declaration of residency. You can also just, get a Florida's driver's license, file your Florida homestead exemption, which, by the way, I'm glad you asked that question, Tom. The deadline for those of you who are applying for Florida ad valorem property tax exemption for your homestead is March 1st. That's coming up. So make sure you do that if you have not done so already. So it's where do you register to vote? Where do you pay your taxes? So I think it's all those things sort of taken together, Tom, that are outcome determinative on where you were declared a resident. For instance, Tom, let me ask you this.
Cool.
Break out, if you had your will in front of you right now, do you have a will in place?
Not a good one.
Okay, but you have one. The first line says, I, a resident of. What state does it say right now, Tom?
Actually, it would say Illinois.
So this is my point. So we get confusion here because you said I identify more as a Florida resident, but we have a document that's declaring you a resident of Illinois. So although I think it's possible to argue out of any taxation from the Department of Revenue in Illinois, you see the gray area there. So this is an example of, we talk about all the time, the biggest mistake in estate planning, people don't do it, but a very close second, people don't update what they've done. And this is an example of that. Updating it is going to lead to optimization of the efficiency. So I think it's a matter of, just making sure you get in and get that reviewed and updated.
Well, another gray area, and thank you, is so I have a driver's license in the Midwest. My wife has one in Florida. My wife votes in Florida. I vote in the Midwest. So, but I from an accounting point of view, my accountant tells me it's the day's test. And we're very careful about being here in Florida 6 months in a day. Is that?
Yeah, I think he's talking about that ad valorem property tax exemption. As far as where do you reside, I think that's what he's alluding to, more than the actually occupying within the state. So, for instance, if you're a professional athlete and you're a Florida resident, but you travel the world for your job, do you think they're worried about being here 6 months in one day?
No.
Right. So I think it's a different analysis for, ad valorem property tax analysis versus Florida residency. So those are two different things.
I don't know what ad valorem property tax is.
Your real estate taxes every year. So under Florida Statute 196, you get a break on the first $50,000 regarding your homestead property.
Okay.
And there's also restrictions on how much they can raise your homestead value of the property every year. So under the Save Our Homes. So there's special protections, but you have to apply for those by March 1st for the following year.
Right. Yeah. No. I'm aware of that. So you're saying though the day's test is not the overriding. If we were to pass and our children were trying to sort out our estate. Mm-hmm. Accountants and tax people would not be concerned about how many days we spent in a certain state versus another. It would all come down to where we declare our domicile.
I think that would be outcome determinative. I don't know that it would be. Other factors could sort. So let's say you file a declaration of domicile in Florida, but then you're registered in another state to vote. You have a driver's license in another state. You own property in that state. You pay taxes in that state. It's possible that declaration could still be overridden by the facts, I think, Tom. And I think it's one of those situations where, it can be confusing and it can create muddy water. So I think the more bright line you can make it, the better. But I think it's going to be a question of sort of what was your intent at the time? Where did you intend to be a resident? And if it's sort of muddied, then unmuddy it, clarify it so that it's less of an. Now, why? I'm just curious too. Why wife registered here to vote with Florida driver's license and you Midwest and voting in Midwest? Is it a first marriage, Tom?
Yes, it's a first marriage.
And so you guys just like different states?
Oh no, we both consider ourselves Florida residents. It's just I need a driver's license up north for other reasons. And actually regarding our business, we've got a fairly substantial business up there. Mm-hmm. It gets it's complicated. It's like you say, it's a huge gray area for me, and we got to get it sorted out.
Well, what I would recommend you do is schedule a consultation with your Florida attorney. If you don't have one, we'll be happy to consult with you, and schedule a consultation with your Illinois attorney. And that way, when you sit down, you can sort of compare and contrast what are the consequences if I declare this my residency and if I declare that my residency. And just to sort of show the rationale, let's say someone declared themselves residents of Illinois. Okay, Tom, but they lived the entire next year in the state of Florida. Do you think the fact that they occupied the state of Florida for a year made them a Florida resident, despite the fact that they declared themselves a resident of Illinois?
I don't know.
I don't think so. I think you can freely occupy wherever you want. I think it's a matter of what was your intent. I think that's the pole star here that everyone's going to look to. So, I mean, some people become residents of a state and then are professional engineering contractors, and they get sent abroad to do long-term project construction. That doesn't make them a resident of that state or other nation state. I think it's a matter of what was their intent. And I think that's the important thing, Tom. And the point you brought up for everyone to highlight is the fact that where you can take measures like updating an old will or updating a driver's license or filing a declaration of domicile just to make it bright line, do so. That makes it so much easier for your surviving spouse or your children upon your passing.
Yeah, and thank you, and that's what we will do. Well, one thing you mentioned though is I need to sit down with a lawyer up north and a lawyer down here to straighten that all out, and then contrast and compare. I got conflicting information on that. I was told by my lawyer up north, you need to create your estate in the state that you're a resident. Period. And he told me he couldn't even do it because he's not licensed in Florida.
Both of these things can be true, Tom. So your lawyer statement was you're telling him you're a Florida resident, and he's saying create the documents in the state of your residency, which you've just told him is Florida. What I'm saying is before you pick a residency, have a consultation with the attorney in each jurisdiction to make sure you know the consequences of that jurisdictional choice, which state you pick and what the outcome of that choice is. So both of these are good pieces of advice. Okay. They're not conflicting.
Yeah. Okay. So that my guess is that's fairly expensive legal exercise, is it not?
I don't charge anything for that consultation. I don't know what the attorney up. Well, I can charge you something if you want, Tom. You just tell me how much. I don't know what the attorney up north is going to charge you. They set their own rates, obviously, but no, it shouldn't be too much for 2 consultations just to get the size and lay of the land as far as which state's residency is going to be optimal for Tom and Mrs. Tom.
Okay. Everybody's told me that to create an estate for me, I'm looking in the $5,000 to $8,000 range. And it would feel to me to be able to make that decision properly, they would need to know everything about us, our businesses, our residents.
That's what the consultation's for, Tom. So we'll walk you through all that at the consultation. My standard trust package, because I believe in making estate planning affordable for everyone. My standard trust package, which is for non-taxable estates, those less than 13.6 million, is $695. And if it's just a standard will, it's $75 is the fee for a will. So the consultation's free. Tom, I'll give out the office line before I wrap up the show if you want to give me a call, okay?
Okay, thank you.
You're welcome.
Thanks,
you're welcome.
I love your show.
Thank you, Tom. I appreciate your kind words. Great listeners like you are the reason why we do it. Have a great Saturday, Tom.
Thank you.
All right, 877-943-9673. Hey, James, hang on the line. I'm going to take you off the air because I got to wrap up the show, but I will talk to you. So just stick around, James. If you have a legal question for next week, 877-943-9673. I'm your host, Attorney Patrick Smith. Again, to reach us at the law office, 877-754-6764. Again, remember, you can always watch the show on YouTube or Instagram at The Attorney Patrick Smith Show, or on Facebook, Attorney Patrick Smith. But again, to reach us at the law office during the week, to book us for your club or group to speak, or to book your complimentary consultation on estate planning, 877-754-6764. To book that complimentary consultation on probate or trust administration as well, 877-754-6764. Everyone stay safe, God bless, and go Gators.